This is John Quinn, and this is Law Disrupted. And today we're going to be talking about a tragedy on a movie set. And the tragedy was that the famous actor, Alec Baldwin, who was also producer of the movie Rust, that was in production at the time in New Mexico, was holding a prop gun in his hand, and it went off and tragically shot and killed Halyna Hutchins, the cinematographer of the movie. This happened on October 21st, 2021. Alec Baldwin was ultimately charged by the state of New Mexico with involuntary manslaughter, and our firm, Quinn Emanuel, was retained to defend Mr. Baldwin. We're going to be speaking with members of our defense team at Quinn Emanuel who were involved in representing Mr. Baldwin and ultimately secured a dismissal of the case for prosecutorial misconduct. We're going to be speaking with my partner, Luke Nikas, who is based in our New York City office, Sarah Clark, who is associated with our Houston and our Washington, D.C. offices, Jennifer Stern and Stephanie Kellerman, who are both based in our New York office. So let me start with you, Luke, and let me ask, how did we first come to be retained in this case? How did Mr. Baldwin get to us?
We had represented Alec in a few cases before that, and so knew him very well, had been successful in representing him. And when this accident happened, we spoke very early on. We were texting the day of the accident, and the production company, Rust, had agreed to provide counsel to all of the producers who were producing the movie. And we had said to Alec that we're happy to stay in the background while counsel represents all of the producers at the same time. But as soon as it became clear that a conflict would arise, the producers may have different interests, the production company may have different interests from the producers, we would be there to represent him. And within a few months, the production company was taking positions that were on some levels adverse to Alec. And so we were retained shortly after that in early 2022.
And what was the course of could you kind of give us an overview, Luke, of the course of the prosecution, the significant steps leading up to his being charged and the case actually going to trial?
In early 2022, the production company lawyer had already started engaging with the sheriff in New Mexico and with the district attorney's office. At that point, they were just talking about getting access to Alec's phone records. And we picked up that conversation. And at the very beginning, told them that we saw no crime, that this was clearly a tragic accident, at least as far as Alec Baldwin was concerned. And we got no pushback from the prosecution's office. They essentially said, we're doing our diligence, we're doing an investigation, and we'll come back to you if we have an issue. But at this point, we're just collecting information. By the end of the summer 2022, we had probably 24 discussions with the district attorney's office. And at no point in time did we have any indication whatsoever that they were interested in prosecuting Alec. They had said some things publicly that were consistent with our view that this was an accident, that Alec didn't intentionally discharge the gun, didn't intentionally pull the trigger. And we had said all along, if you come to a conclusion that you're intending to prosecute or you see problems with Alec's conduct, please let us know right away. We'll fly down there. We'll explain why you see it in a way you shouldn't see it, why you should see it our way. And they assured us they would. Toward the end of the summer, the district attorney who was handling the case, the first assistant, left the office to become a United States attorney. And at that point, the district attorney appointed a special prosecutor to get involved. That was our first indication that maybe they were interested in pursuing Alec, but they assured us that it was simply because the office didn't have adequate resources to investigate a case like this. And so we reached out to that special prosecutor. said that we wanted a meeting if there was any indication on their side that they were interested in prosecuting him. And they said, again, we're just investigating. We're just looking at the facts. We're not at that stage yet. And so that was the conversation through the end of 2022. We had no indication that they were interested in charging Alec. Early 2023, so January, first few weeks, we again said, you've had the report from the sheriff for quite a long time. You haven't let us know anything. We assume you're not interested in prosecuting him, but if you'd like to have a conversation, we're willing to provide you our perspective on facts. They said, that sounds good. Let's have a conversation. So Alex Spiro and I had a discussion with the district attorney, the special prosecutor, and another person from the district attorney's office. And we explained in big picture our view of the case, why it wasn't a crime. They said, thank you very much. We'll be in touch. That night, the special prosecutor reached out, called me and said, we do have one serious concern about Alec Baldwin. What's that concern? She said, we have reason to believe he's deleted information from his phone, and we're considering charging him with obstruction of justice. It turned out that their paralegal was looking in the wrong files for the information that you'd expect to find on Alec's phone. I pointed her to that file. She said, thank you very much. That alleviates our concern. Thank you very much. If you have any more, please let me know. Of course we will. The day before they announced the charges, they said they were going to have a somber announcement. They were going to indicate who they would be charging, and they would then proceed with the case. We had zero indication they were charging Alec at that point. That was the only conversation leading up to charges, the one I just described.
Isn't that kind of a surprise? Don't prosecutors typically give a heads up, especially if you've been in conversation with them the way you had been?
They promised us multiple times that if they were going to charge him, they would tell us, and they'd give us an opportunity to come down and explain why they should. The morning that the charging decision was going to be announced, I got a phone call from the Wall Street Journal. The Wall Street Journal left a message on my phone saying, we have been told that Alec Baldwin will be charged with involuntary manslaughter with an enhancement that requires mandatory 5-year sentence. Do you have a comment?
So they had leaked it. They didn't talk to you, but they leaked it to the press.
They leaked it to the press. 10 minutes before the time of announcing charges, I got another voicemail. I was in court at the time. I got another voicemail from the district attorney, and she said, as promised, I'm calling to give you the advance notice that we'll be charging Alec Baldwin with involuntary manslaughter. 10 minutes before she posts it on the internet that they're charging him. And so at that point, we realized they were interested in pursuing him aggressively. They were interested in pursuing him without giving us the normal courtesies that would apply in the context of discussions leading up to a prosecution. And so we knew we were in for a war with this prosecution team. And that was reinforced because immediately after the announcement they made of charges, which they said would be a somber announcement, they went and did the press circuit on the Sean Hannity show. They went on Fox News. They went on CNN. And the essence of the press message was Alec Baldwin committed a crime. This is a 5-year mandatory sentence. Plus, on top of that, the involuntary manslaughter charge comes with an additional 1.5-year sentence. And we're going to pursue him. Celebrity doesn't mean you get to escape justice and truth, and we're going to go get Alec Baldwin. And so,
what was the enhancement?
There was a use of a firearm in the commission of a felony. It gives rise to a 5-year mandatory sentence in New Mexico. The purpose of the enhancement is for situations like a bank robbery. Bank, they want to encourage you not to use a gun because obviously that creates a greater possibility of death and serious harm. And so if you use a gun in the commission of a felony, you get a 5-year mandatory sentence. The problem was not only was it not the intention of the legislature to impose a 5-year mandatory sentence in this context, this was an accident on a movie set, but the statute that was enacted to impose the 5-year minimum mandatory sentence wasn't enacted until after October 21st, 2021. And so it didn't even exist as law when this accident happened. And so at that point, we knew not only were they going to come after Alec Baldwin really hard, but they were going to come after him in ways that showed carelessness in how they approached the case.
What are the elements of involuntary manslaughter in general? And I address this to any one of you in general under New Mexico law. I asked because Luke, earlier you said that Alec Baldwin didn't intentionally do anything, and I would is intentionality, intentional act part of the element of a involuntary manslaughter?
We argued that indirectly it was, because involuntary manslaughter, in essence, is when you engage in conduct that is likely to pose a serious risk of death or serious harm to another human, and you do so in reckless disregard for that person's safety or life. And the recklessness component doesn't have actual intent. You don't need to want to do it, but you have to recklessly disregard the circumstances, knowing, in essence, almost to the point of knowing that you're going to cause that risk. What we had argued, to sort of put a finer point on it, is that the only way that Alec Baldwin would have had any sense of whether he was likely to create a context of harm that could kill somebody or cause serious bodily harm is if he knew that the gun had live bullets in it. This is a movie set. The gun was not supposed to have live bullets in it. There wasn't supposed to be live bullets in the church, in the gun, on the entire property. This was supposed to be make-believe. And so we argued that in order to show the level of recklessness required to prove involuntary manslaughter, he had to know or have a really, really good reason to believe that gun had live bullets. And so it wasn't intentionality, like you go out to hit someone in the face and therefore you're intending to punch them, intending to cause that harm, and therefore it's a battery. But it has to rise to a level close enough, because we're talking about manslaughter here and not a misdemeanor.
All right. All right. So to go back to the sequence of events, the government announced that they were charging him and presumably filed the charging documents, charging him with involuntary manslaughter. And then what happened?
So immediately we put together a team to focus on 3 different categories of the case. The first was motion practice related to the actual crime charged. The statute that created the gun enhancement, the 5-year mandatory minimum, was an ex post facto law as applied. And so we had a motion prepared to get the gun enhancement dismissed. At the same time, we put together a group that was going to focus on the roles of the prosecutors. So the special prosecutor was at the same time running for the state legislature in New Mexico. And the state legislature was part of the legislative branch. The prosecutor was part of the either judicial branch or the executive branch. It wasn't clear in New Mexico, but certainly not the legislative branch. And so we argued that this was a violation of the separation of powers. She couldn't serve in the state legislature while simultaneously prosecuting Alec Baldwin. So we filed a motion to disqualify the special prosecutor. And then number 3, we focused on what we needed to do immediately to start getting discovery and start preparing for a preliminary hearing. In New Mexico, you can charge by grand jury indictment, or you can charge by a complaint that gives rise to the right to test the complaint through a preliminary hearing in front of the judge. That's the way the prosecutors went the first time around, no grand jury. And so we started sending discovery requests and putting pressure on the prosecution to turn over information. From there, the court didn't need to get involved. The special prosecutor resigned before the disqualification motion was heard. They dropped the gun enhancement before it was heard by the court.
Did the special prosecutor say why he or she resigned?
She said it was because she didn't want to create the type of distraction that big law firms with their expensive lawyers try to create by running up billable hours and attacking people doing justice, something to that effect. And so it was a really interesting comment, and they had made some comments like that before that demonstrated that they weren't going to operate within the four corners of the ethical rules governing lawyers, which are, with respect to prosecutors, even more stringent because the impact that a prosecutor can have on a prosecution by making statements like that. And so there was an avalanche of press attacking the district attorney for those types of comments. There was an avalanche of emails. We were getting them. They were saying they were sending them to the district attorney's office, putting pressure on that office to start getting in line with how prosecutions ought to normally be conducted. And so with that sort of extreme public ridicule, plus the disqualification or the recusal before, plus withdrawing the gun enhancement, the district attorney appointed a new special prosecutor, who then brought in another special prosecutor. And so we immediately engaged with her to see if the tone would change. And at that point, it did with the new special prosecutor.
How so?
So she said immediately, I have an open mind. I see what's happened. It's been, in sum and substance, an embarrassment for the district attorney's office to have conducted the initial steps of the prosecution this way.
By this way, you mean in the press?
In the press.
And making the kinds of comments they did?
In the press, with the comments, with the mandatory minimum sentence that didn't belong in the charging document, with the separation of powers issue. At the same time, we were pursuing the substantive discovery. We learned through a FOIA request that that special prosecutor, the first one, the one who resigned, was communicating with the district attorney and said, make sure when you announce the charges or you announce the case, you tell the world or you tell the public that I'm involved because it could help me get elected to the legislature, LOL. Laugh out.
No kidding.
And so we saw the sort of internal motivations, pretty publicly very early on. And this new special prosecutor told us that's not how she would conduct this prosecution. She thought it was wildly improper the way they had conducted themselves, and she was going to try to start a clean slate. And so after a few conversations, I said to her, well, if you'd like to have a conversation, the one I've been trying to have with the district attorney's office for several months now, we'll come down there and we'd like you to listen to why we don't think charges should have been brought in the first place. And she said, I welcome that. Come to New Mexico. We'll have that discussion.
And did you do that?
We did. We put together a roughly 100-page PowerPoint deck. Sarah Clark and I flew down to New Mexico, went to Santa Fe, met with the two special prosecutors, and walked her through from start to finish why the law didn't support this as it was, the facts didn't support this charge, any charges, and how public opinion, smart public opinion from judges, from other lawyers, had commented on this case. And the general consensus was this case never should have been brought as a criminal charge. Very productive conversation, several hours. Sarah and I left feeling positive about the possibility that the prosecutor would drop the charges. And she ended up following up within about a week and said, I'm seriously considering dropping the charges. I have to do a little bit more research on some of the jury instructions you gave me that are impactful, and I'll get back to you as quickly as I can. That was a Friday. On Saturday, I got another phone call from her saying, I'm really thinking about dropping charges. I'm going to speak with the lawyers involved for the victims, and I have to get back to you. On Sunday, she said, I think I'm going to drop the charges. And so our optimism was building.
Yeah, and at this point, you must be feeling pretty good that you and Sarah had an impact on the special prosecutors thinking about the case.
It was 180 degrees from the very beginning with the initial prosecution team. And so we felt we had made a big difference. Monday comes around, she says, I'm going to dismiss the charges.
Amazing.
And so we feel great about it. On Tuesday, she said, I'm not going to dismiss the charges. We should just have a preliminary hearing. On Wednesday, she says, I say, Tuesday night into Wednesday, I say, let's get on the Zoom. I have more information for you that I have not told you. And she said, if you can give me any indication that that gun did not require a trigger pull, even a plausible story and evidence to back it up, then I will dismiss this case. And I said, we've been told by our gun expert that it is possible that gun didn't require a trigger pull to fire because of modifications that were made to the hammer. And she said, show me the pictures. And so we showed her some of the pictures our gun expert had given to us, showing how the hammer, certain notches of the hammer were much smaller than they would be if they had not been modified. Showed her other portions of the gun that appeared to be filed down and so shiny and not matte or sort of rough. And she said, let me talk to my gun expert and see if this is plausible. She comes back to me the next day and says, he says it's plausible in that context. And given everything else you've told me, I have to dismiss the case.
But Sarah, let me just ask, Sarah, you had responsibility for issues relating to the gun. That was kind of the subject you were assigned to.
Mm-hmm.
Why on earth would a gun be modified so it could fire without the trigger being pulled? I mean, Sarah, what's the backstory there?
Yeah, so the type of firearm that was at issue in this case is it's an 1873 old school 6-shooter revolver. It's like what you see in all the cowboy movies. And it's a very simple machine, right? But it has historically had a pretty light trigger pull. And it's the kind of gun that people use in sharpshooting competitions where they're shooting to see who can go the fastest, right? Nobody needs a 6-shooter revolver anymore, right? But it's still a sport. So there was a very real reason to believe that the gun might have been filed down. There's sort of two parts that interact. It's called the hammer and the sear, and they interlock. And when you pull the hammer back, that's when it releases a piece of that metal sort of lip. If you file down that metal lip a little bit, you can achieve sort of a less significant angle, right, of interaction of these two parts. The gun will fire more easily, it'll fire more smoothly. So it is the type of weapon that could be modified for sport, basically, to make it a better gun for sport shooting.
Well, what was the defense position, that it did not require any trigger pull at all, or only a very light trigger pull?
So the problem in this case was that we could never know the answer to that because the gun had actually been destroyed in the course of the investigation during FBI testing. And the two parts that interlock that I just spoke about are precisely the two parts that had been broken in the course of that testing. So our position was that there were indications on the gun that some kind of gunsmithing could have occurred here. But we would never know exactly how much because of the state's decision to destroy the firearm in the course of their investigation without telling us, without telling any of the defendants. They basically quite literally smashed it with a hammer, and that destroyed those two critical parts.
That seems like such a blunder with a key piece of evidence. I don't understand how law enforcement people could do that, knowing the problems that would create in the prosecution.
Yeah, I think we came across a lot of issues in this investigation that we felt were blunders, showed carelessness, showed that it wasn't being treated like a serious investigation. Some aspects sort of looked like, there was a disconnect between the prosecution and the police force, right? And the right hand didn't always know what the left hand was doing at the beginning, anyway, of this investigation, although later on, it sort of turned out that the prosecution took a more sort of directional approach to the investigation. But I think, the critical question in this case that the investigation frankly never bothered to answer is where the live ammunition came from. And so I think the gun testing it happened, they sent it off, but no, they weren't careful. And they didn't pay attention to the rights of the potential defendants in this case.
Okay, Luke, let's go back to the narrative that you were giving us. She said, if you can show us any evidence at all that a trigger pull would not be necessary, I will dismiss the case. You sent her some photographs, and then what?
And told her where I got the photographs from, our gun expert, who's highly respected in the field, and what he said. And she came back the next day and said, my gun expert has significant respect for yours, knows who he is, and says that the information you have been provided by him and provided to us is plausible, so I need to dismiss the case.
Well, again, you got to be feeling pretty good at this point.
Feeling good, but at the same time, not holding my breath, given what had happened over the past few days. And then she tells the press, she sends me a stipulation of dismissal, and she dismisses it without prejudice. And I said, without prejudice? She said, don't worry, it's not coming back. I'm putting without prejudice because I want to continue doing an investigation related to the gun, related to everything else, but don't worry about it. This case is not coming back. The press comes out, it announces the dismissal, and she tells me, like, when is this going to get passed? When is this going to be behind us? I want to focus on, pursuing the rest of the case. And I essentially said, don't worry, it'll be, in the rearview mirror quickly, and then you can go off and pursue the rest of the case. And so that was the conversation I had with her in early 2022. And then she continues to, 2023. And then she continues to do her investigation, pursue the armor in that case. And every 2-3 weeks, I ask, how's it going? How's the investigation going? You finding anything interesting? Because she was giving me some information that was useful actually in our defense in the civil cases, related to people she was speaking with. And I had a good relationship with her, and she was sharing that information. End of the summer, she reaches out and she says, I have great news for you. So Thursday evening, I have found information about how the live bullets might have gotten on set. And I said, that's great. She said, I'm going to go out there. We're going to have a meeting. I have a metal detector. We're going to go out on the set. I'm just keeping you posted. And it has nothing to do with your client. And I said, well, that's great, as we would expect. Thank you for telling me. I thought you'd want to know, because every piece of information I find just continues to exculpate your client. I said, well, I saw the news about how you charged the armor with using cocaine on set, which obviously is something that, if it's true, could have had an impact on how the armor was conducting herself and an intervening cause from Alec Baldwin's perspective. Exactly, she says, this is all good news. About a week later, I get an email from her saying, we've studied very carefully the case, and it is our firm view that your client committed involuntary manslaughter, and we are going to be pursuing him and convening a grand jury and seeking an indictment for involuntary manslaughter to pursue a criminal case.
Another total reversal.
Total reversal, completely out of the blue.
Which it's from somebody you've been speaking with, doesn't bother calling, just sends you an email.
Exactly. Just sends an email, and she's going to convene a grand jury. And she says, I'm going to give you a schedule for the process of meeting with the grand jury judge, submitting any information you want the judge to order me to present to the grand jury. I'm willing to work with you on the schedule. And I wrote back, great. She serves about a week or two later the grand jury notice, which starts the clock for us to present to her exculpatory information or relevant information we want her to show to the grand jury. And I propose a schedule. And she says, no. I'm cutting your time to present to the grand jury, shorter than the time that she was giving to the armorer, sort of a uniquely short deadline to Alec Baldwin, a deadline that violated New Mexico law. And she was pursuing the grand jury on an extremely quick schedule.
Did you then or at any point get any insight into what had happened? Why this reversal in position?
She claimed a variety of different things throughout the case, had claimed that we threatened to sue her, had claimed that we were in possession of videotapes, so we should know that Alec Baldwin acted differently on set than what we had previously understood. We, in fact, didn't have any of the tapes on set at that point. The tapes didn't show that he acted the way that she claimed he had acted. We didn't say anything to a reporter. And so there were a number of different excuses that we heard. None of them were actually consistent with the facts. And so we chalked it up to an interest that had been revived in pursuing Alec Baldwin because he was Alec Baldwin, and the amount of attention that anyone involved would get from pursuing a case like this.
He was always Alec Baldwin. That always would have been true. It doesn't really explain the multiple reversals in position.
It doesn't. And so we had speculation along those lines and others, but we never really figured out what they were trying to accomplish. We just knew that at that point they were going after Alec Baldwin.
All right, so the case goes to the grand jury.
Case goes to the grand jury. The grand jury judge orders that the information we had requested be presented to the grand jury with very, very minor exceptions. And so we got very good rulings in the grand jury process. The grand jury was not shown the information that we had prevailed in requiring the prosecution to show. And the grand jury process was supposed to be under seal, but the prosecutor was still telling the media what was going on in it in violation of the court's orders. And so the process was procedurally really out of tune with the way it was supposed to be, but went to the grand jury indicts, and now we have a case.
The indictment comes down when?
The indictment comes down in the beginning of 2024.
And the trial starts?
July 2024.
So what happens between January and July?
So at that point, we had a number of different strategies in place. We had a dozen motions plus that we wanted to file related to evidentiary issues, the destruction of the gun, other evidence that we were entitled to that ultimately was not produced to us. We had motions related to the grand jury process. She was required to present that information to the grand jury and didn't. She was required to allow all the witnesses answer the grand jury's questions when they were posed. She would interrupt witnesses in the middle of answering the questions to divert the topic to a different topic. So we filed a motion to dismiss the case on the basis that the grand jury process had not been conducted according to law. We had motions related to almost everything you can imagine, given how careless this prosecution had been. We also immediately convened as a team, and Alex Spiro said, we need to get a trial as quickly as we possibly can. We are ready. We will always be ready, no matter what. We need to get the schedule moving.
The thinking being that the prosecution wasn't ready or wasn't as ready as we were or could be in the same time frame.
The thinking being primarily, this is the best litigation firm in the world. It's the best trial team, best trial firm in the world. And there's no schedule, within reason, of course, that we won't be more prepared than any opponent we're up against. And so if we just put together the strategy, the resources, and we worked extremely efficiently to get the information we needed, to file the motions we needed, we would be able to chug along at a breakneck pace and be ready for trial in far better form than the prosecution would. And so Sarah, Stephanie, Jen, some other members of the team, Michael Nosenchuk, they interviewed dozens and dozens and dozens of witnesses and spoke with a handful of experts to put together a record for trial in faster than I've ever seen done before. At the same time, we filed thousands of pages worth of motions to protect our record, to start exploiting the flaws in the prosecution's legal case and the way they handled discovery. And at the same time all of that was happening, we were making document demands that did two things. One, locked the prosecution into the position that they had produced all the information they were required to produce, all the physical evidence, all the documents. And number two, for what they did actually produce, get the information we need to put together our defense. And so at that point, we had all vectors going at 100 miles per hour, according to a strategy that was devised pretty much on day one.
So Jennifer and Stephanie, I understand that you had responsibility for various witnesses, both interviewing prospective witnesses, working with experts, and then as the list was narrowed down, working with people who you actually thought were witnesses that we would call at trial. What was that whole process like in those months when, as Luke described, you were working at 100 miles an hour?
So I think in preparing for the pretrial.
This is Jennifer Stern, by the way.
Yes, hello, thank you. In preparing for the pretrial interviews, I think it was very important to get a firm grasp on all the prior statements that these witnesses had made. It was sort of a unique situation in that a lot of the witnesses had already testified in the armorer's trial and had done pretrial interviews in that case. Some of them had spoken out publicly in the press, as Luke mentioned earlier. So I think there was a lot of catch up to be done in building the outlines and the frameworks for those interviews and understanding what gaps needed to be filled and how these witnesses impacted our case and our defense. And we ended up interviewing, I think, over 50 witnesses in the span of 2 months. And I will say, as a junior associate who was still pretty new to the firm at that time, it was an incredible opportunity to be given that level of responsibility as soon as we joined the case. And I'm sure, Steph, you can add to your experience and how we got to cross outlines and all that.
So Stephanie Kellerman, tell us what that experience was like for you and what were the activities you were engaged in?
Yeah, so we were essentially doing document discovery while doing the sort of New Mexico criminal equivalent of depositions while preparing for trial. And it was a lot of moving pieces. And then we also had the team doing dispositive motions at the same, literally all at the same time. So there was just an immense amount of coordination that needed to be happening. And we had to be, as we learned each piece of information, incorporating that into asking questions to the next witness, sending out discovery requests, building it into witness outlines. And we're doing all of this while also being very careful that we're not going into interviews where the prosecutor is sitting in on all of these and giving away our strategy or giving away what we're interested in. And so we're trying to get information while also being, vague and sort of wandering around and getting background to get the thing that you're laser focused on, because we had to be so laser focused in order to do all of this in such a short amount of time with not that many resources. And so it was, I think this team did a really good job of every time there was an interview, everyone understanding what was learned in that interview and coordinating on that level, but also having sort of our subject matter niches. So like Sarah became the absolute expert on the gun stuff. I started off focused really on like the medical portion of the case, which we didn't really get there in the trial, but was a part of the case in the armorer's trial. And then Jen and I were both very focused on the law enforcement and the investigation aspect. And then I became more focused on, how the supplying of the props and the bullets and how that all worked. And Jen became very focused on the norms on a movie set and that sort of course of conduct, and really understanding how each of us had this expertise to any question coming up, just really, really referring to each other all the time was like really how we got through it and at that pace.
I mean, were you working basically 24/7?
Yes.
What were the subjects of expert testimony that we lined up on the defense side?
So basically the expert testimony in the case that was going to come through was focused on either the firearm and the operation of the firearm, and then on industry standards in the film industry for the behavior and the responsibilities of actors, armorers, and anyone touching a firearm, and then on the medical issues, so causation kind of related issues surrounding the treatment of Ms. Hutchins.
Let me ask the question that everybody asks about this case. And that is, why were there live rounds on the movie set? Did we ever learn the answer to that?
We don't know for sure why there were, but at the end of the day, there were. There was a prop supplier who supplied prop guns and dummy bullets. There were people who were supposed to have checked them. We don't know if they were inadvertently put in one of those batches, whether they came through the armorer's satchel, whether they were, part of a larger batch of bullets that ultimately moved around from movie set to train actors off the movie set on how a gun shooting a real bullet would feel so they could replicate that on the movie set. We don't know the definitive story, but what we do know is that the way the case ended was that we learned from the witnesses who testified that an individual walked into the sheriff's office, said that he had bullets that came from a batch of bullets that were basically traveling from movie set to movie set, live bullets, so that an individual could train the actors on how to shoot a real gun with real bullets to be able to act in the same way that with dummy bullets, they would look and feel with real bullets, and that ultimately they may have gotten mixed in with the prop bullets that came to the movie set. And that information was concealed from us in sum and substance in significant ways. But that was the end story that we learned as for the source of the live bullets. But we didn't have the opportunity to take detailed discovery of that information, because when we asked for documents that would have encompassed that, we didn't get documents. When we asked for all physical evidence, bullets, etc., that would have encompassed those bullets, we weren't shown those bullets. And so at the end of the day, we didn't have the opportunity to go down that path because it was concealed from us. So the answer to your question is, we have a lot of possibilities, but we were denied the opportunity to figure out which one is the actual one.
Well, we want to hear about that denouement and how the dismissal came about. But did the dummy bullets look exactly like the live rounds? Visually, can you tell just by looking?
So I can do this one. The answer is no, and I know we're not on video, but this is a fake one.
Sarah's holding up a fake bullet.
I'm holding up a dummy round that we got from our expert. This looks like the ones that were on set, except for one small feature, but they look identical. They're made to look identical. It's the whole point of a dummy round, is that when there's a close-up and you can see every detail of the cartridge, of the head of the bullet, of the head stamp on the bottom, it looks identical to a real round. And in fact, it's made of the same components. It just doesn't have an explosive in it. So the concept that he should have just known because it was obvious is just entirely off base.
Okay, well, it's been very widely reported that the case was dismissed for prosecutorial misconduct, specifically failing to turn over to you exculpatory evidence. So what can you tell us about how that came about? What were the events leading up to that? What was the exculpatory evidence, and why was it exculpatory?
So the short story, because it unfolded over the entire trial and there was some preparation, is that an individual named Teskey was a former cop, local judge, was friendly with two individuals who were involved in the movie business. One was the armorer's father, and the other was a prop supplier to the Rust movie. And he told the sheriff's department, in the actual department, walked right in.
So he's like a volunteer. He just shows up.
He shows up. Good Samaritan is what we called him in the trial. And he shows up at the sheriff's department and he says, I have evidence related to the Rust movie. And they say, what's that evidence? And he says, in essence, there was the armorer's father and the prop supplier. They came to my house and they dropped off a batch of live ammunition, because I have a better storage facility for it than the armorer's father does. And I stored it. They came back to my house later on and picked up some of those live bullets. And they brought them to a few movie sets in order to train actors offset how to fire a live gun and ultimately replicate what it would look like to fire a live gun with the kickback in the context of acting out a movie with dummies. He continues and says, I believe that this could be the source, this batch of the live rounds that were brought to the Rust movie set, if that prop supplier who got these live rounds with the armorer's father mixed into the dummy bullets, the live bullets from this batch. And he says, here they are, and I'll give you a statement. I want to make sure this evidence is memorialized because this could be highly relevant, and I want you to make sure it's put to the appropriate use. And so the sheriff's department takes a statement from him outlining all of this information. They call it a supplemental report. They put in the report a miscellaneous case number, and they file it away under a different case number with no name, not under the Rust case number. We learn at trial, the prosecutor, the special prosecutor, the new one, was involved with members of the sheriff's department who had decided to bury this report and bury this evidence and not disclose it to us. We learned that at trial. And so the case ends because the judge on Friday, after hearing oral argument and our motion as to why this was a disclosure required under New Mexico law and under Brady, the judge orders that the bullets be brought to the courtroom. And the bullet that killed the cinematographer was a Starline brass 45 with a nickel primer. The judge orders the bullets that Teskey had brought to the sheriff to the courtroom. The judge comes off the bench, puts on gloves, looks at the bullets that Teskey had brought to the sheriff's department, Starline brass 45 nickel primer, matching in all those components to the live round that killed the cinematographer. And so we had set up the trial in part to demonstrate that law enforcement's motivations were to come after Alec Baldwin, not to pursue the entire story of what happened on that movie set. And we had done a number of different things at trial and so had the state, that were reliant on the fact that there was no evidence of where the live round could have come from. We didn't know about that supplemental report. We didn't know that it had been filed under a separate case number. We didn't have the bullets. They weren't brought to us, for example. Teskey didn't say, here are the bullets, you should check them out. And we had asked for full disclosure of all bullets and other documents in discovery. And we were told we had been given everything, but the state concealed this information from us. And so ultimately, the judge ruled that this evidence was highly relevant to the case. It was highly relevant to the way in which we had conducted our defense, and the prosecution was required to disclose it. And the prosecution took the position that it wasn't all that relevant because whether the live rounds came from this person or somebody else didn't matter. But at the end of the day, one of the key prosecution themes was that the armor was, purple hair, young, careless, reckless, brought live bullets to the movie set, was part of the story. And Alec should have been on notice that this was not a safe movie set, and definitely not safe with respect to gun handling, because he was relying on this person, this armor who brought the live bullets with the purple hair. And so the state had set up the armor as the one who was responsible in order to implicate Alec Baldwin, but meanwhile had in its back pocket the fact that maybe the bullets didn't come from her, came from somebody else, and ultimately there was a potential intervening cause and an issue with respect to state of mind that they didn't allow us to explore. The judge said, that's enough. We're in the middle of trial. You didn't disclose it. And the key test here is not what Alec Baldwin's lawyers knew or didn't know about these bullets, whether they knew everything or whether they knew nothing. The test is whether the prosecution complied with its disclosure obligations. And because you didn't, and the defense was allowed to rely on that, in the middle of this trial, for me to adjourn it, highly prejudicial. For me to just require disclosure, it's not going to remedy the problem. So case dismissed.
Yeah. So the fact that there was this other source of bullets was inconsistent with the prosecution's theory that they all came from this young, inexperienced armorer who was the source of the bullets, and that Alec Baldwin, producer, guy in charge, had given her too much responsibility, and was part of their theory of recklessness?
Well, not with respect to the producer, because we got the producer liability theory excluded motions in limine.
Okay.
But it was in his capacity as an actor. He was very familiar with armors on movie sets. He's a very experienced actor. And he should have known the theory was that he couldn't have relied on Hannah Gutierrez Reed because of all the carelessness she demonstrated on the movie set. And that's illustrated by, among other things, the fact that she brought live bullets to the movie.
All right. Well, we saw that on TV where the judge dismissed the case, and the really emotional outpouring in the courtroom. Mr. Baldwin was, I think, openly weeping. I saw all of you with smiles on your faces. Tell us what that was like, Stephanie and Jen.
I think it was a really incredible moment because, sometimes we feel like when you go through the justice system, civil or criminal, there's no sort of vindication at the end. There's an outcome, and that might be good for you or bad for you. There's no vindication that you shouldn't have gone through it. But here we got, I think, as close as one could ever come to vindication that this entire thing was wrong from the start. This entire prosecution was a witch hunt. The game was rigged. The rules weren't followed. That the prosecution and investigative team involved was willing to do whatever it took, even if it meant crossing ethical boundaries, to prosecute Alec Baldwin for their own personal gain, despite that case not even really making sense. So for us, I think in some ways, this was better than a total acquittal because it said, you shouldn't have had to go through this at all. And so to be there to see, the judge's very, I think, emotional reaction to having learned the degree of misconduct here that we had been exposed to in smaller doses over, the course of witness interviews, and just the demeanor of the prosecution and how they approached this case, but to see the degree of it come out in court and to have us learn that and the judge learn that. I remember there was a moment where the lead detective said that she was aware of the fake report that was created essentially to hide this evidence. And all of the reporters in the courtroom audibly gasped. It was beyond anything that we could have fathomed. And so to get to see, the judge say that there is absolutely no tolerance for that in the state of New Mexico, and to know that that meant that it was over. And also for Mr. Baldwin's family, who was all sitting behind us, the absolute relief that brought, and knowing that it was over, and we wouldn't have to sit there and wait for a jury to tell us that this prosecution didn't make any sense. I think for us, especially at the pace at which we litigated this case, having, given up, there was a huge amount of personal sacrifice, I think, from every member of this team, having given up not only weekends and nights, but, not having slept for many, many months on end, and poured every single thing that we had into this. It just felt like this was one of those rare instances in which it was such an amazing outcome that we would have never expected.
Jen, what will you most remember about this experience?
Oh gosh, that's a very hard question. I mean, I think top of mind right now, just because of the question that you just asked and Stephanie's answer, it'll be hard to forget that moment of watching. I mean, I was back in the war room actually on that day prepping for my next witness. And so watching all of that unfold live, as so many others were, was just such a surreal experience. And I couldn't have been more proud to be part of this team and led to a result and an achievement. What we knew was the only just result from the very beginning, is a feeling and a moment that I'll never forget. So lots of memories, but I think the end result really was unforgettable.
Well, congratulations to all of you and to the other members of the team who are not on this podcast for such a fantastic result and seeing that justice was served. We've been speaking with Luke Nikas, Sarah Clark, Jennifer Stern, and Stephanie Kellerman, lawyers who I'm very proud to call my colleagues. This is John Quinn, and this has been Law Disrupted. Thank you for listening to Law Disrupted with me, John Quinn. If you enjoyed the show, please subscribe and leave a rating and review on your chosen podcast app. To stay up to date with the latest episodes, you can sign up for email alerts at our website, law-disrupted.fm, or follow me on X at JBQ Law or at Quinn Emanuel. Thank you for tuning in.